number C338469, State vs. Julie Hamilton. This is our continued evidentiary hearing, right?
That's correct, Your
We
Honor.
heard from the two witnesses for the state
Correct, Your Honor.
last week, and I think we're just reconvening today for the house arrest officer.
That is correct, Your Honor. Officer Crunden is present.
Thank you.
Yep. You guys want to state your appearances for the record real fast?
Alissa Engler, bar number 11940 on Chelsea Callis. I don't know your bar number. 13902. For the state.
Jason Weiner, bar number 7555, on behalf of Ms. Hammer, who's president.
Okay. So, you want to call your witness?
Yes, please, Your Honor. Officer Crunden.
Have you come up to take a witness stand? Once you get there, please remain standing. Raise your right hand, be sworn.
I do solemnly swear that the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you. Please be seated.
Officer, could you please state and spell your name for the record? Sorry. I beat you to the punch.
Yes, you did.
I'm sorry.
David Crunden, D-A-V-I-D, Crunden, C-R-U-N-D-E-N, middle initial C,
And Officer Crunden, how are you employed?
with Las Vegas Metropolitan Police Department.
Okay, within Metro, do you have specific duties?
House arrest.
And as part of your house arrest caseload, is Julie Hammer assigned to you?
Yes,
And do you recognize this Hammer here in court?
yes.
Could you please point her out for the record? Ask the court to accept the officer's ID.
Since there's not very many people in here, I think that's okay. Usually you're asked to describe or
We all do it, but
say something that she's wearing. It's fine.
does she have hair?
Yes.
Perfect. And Officer Crunden, how long have you been assigned to Ms. Hammer's case?
Approximately a year, probably. I don't know the exact amount of time.
And during that approximate year, have there been any issues on house arrest for Ms. Hammer?
No.
Now, Ms. Hammer was ordered to stay away from an address on, I believe it's Falcon Ridge. You're aware of that, correct?
I was not aware of that.
And can you, Ms. Hammer is on a GPS tracking system, is that accurate?
Yes,
And did you download the GPS tracking information from Ms. Hammer?
yes,
And did she approach that Falcon Ridge address any time during the last year?
no,
And do you have any indication that she could have done it without your knowledge?
no. Well, there was a stretch where she wasn't on house arrest, so I can't count for that time.
Okay, but during the period of time she was on a house arrest and on your caseload, she has not done so? Nothing further, Mark.
Just a few questions. Officer Crunden, your role in monitoring Ms. Hammer is generally based on the GPS monitoring, is that correct?
Yes,
So you don't monitor her telephone calls?
no,
You don't monitor her computer usage?
no,
So if there was contact made between the minor child and the defendant through a computer, you would have no knowledge of that?
correct.
And that wouldn't be documented in any report that you could verify for the court?
No.
Nothing further.
I have one quick question. Officer Crunden, if Ms. Hammer had proceeded to that residence to deliver a computer, a tablet, something like that, there would be a record of that in the GPS computer system, correct?
Correct.
And there is no such record, correct? Nothing further.
Okay, that was fast. Thank you. No problem.
After all that.
Did you guys want to make arguments?
Judge, the defendant was arraigned in district court on March 19th of 2019 in front of your honor. At that point, and the minutes specifically state that I stated there was concerns that the no contact order between the defendant and the victims in this case had been violated, and there was expressed concerns, and I requested that the court admonish the defendant to comply with the no contact order. At that point in time, the court did admonish the defendant to comply with the rules. This was in March 19th of 2019. Additionally, as I stated and you heard from Ms. Wilburn, there is a no contact order in place through the family court. The family court is currently stayed pending the outcome of this case. But regardless, there's no contact orders in both cases, and the defendant is well aware that she was not to have contact. No contact means no physical contact, no telephone contact, no computer contact, no contact of any kind. She clearly violated that. You heard testimony from Mary Rasmussen, who said that she physically saw the defendant speaking on the computer. You heard from Donna Wilburn, who said that London but confirmed it during their session. And she has serious concerns about the mental health stability of the minor child as a result of this. We brought this motion because we had clear evidence of a violation. I've had suspicions for the last 9 months, but I didn't bring anything before this court until I had concrete proof, direct evidence from somebody that physically saw the two of them speaking. We have that here. I think the state has met any burden to show that the defendants violated this order. We're asking that her bail be revoked. At a very minimum, we're asking that the court hold the defendant in contempt and put her in custody pending trial.
Your Honor, the state produced 2 witnesses and some videos. The videos were, the court saw them yourself. The only person identified in it, I believe, is when London screamed out "Grandma." We could not hear anything else. We certainly could not hear Ms. Hammer's voice. And there was nothing on the video in terms of visually. It was just, I guess we were supposed to listen to it. Now, neither of those videos shows my client either orally or visually having contact with London. In fact, throughout the whole thing, Your Honor, the one thing I'm almost happy my client's on GPS house arrest at this point, because I know the court had a concern to last hearing about this tablet that she began using after the fact. The court was concerned that my client provided it. That's why Officer Crunden's testimony was so important. My client hasn't been anywhere near that residence in a year. We have proof from Metro. Now, the conversation with Ms. Wilburn, she states it's taken out of context. London never really admits that she saw her mother. It's just all signaling negative inference. Your Honor, there's no clear and convincing proof my client contacted London because she hasn't. If she was going to violate the court's order, she wanted to see her daughter in person, not over the internet. That contact was with the grandmother who is not subject to the order. We'll submit it on that, Your Honor.
Judge, just a couple of things. This court is well aware there's a period of time that the defendant was not on house arrest. Officer Crunden said that he can confirm her whereabouts only for the time that he was monitoring her. I believe it was about 33 days or a period of time that she wasn't on house arrest. So if she went over to that residence, we would have no way of knowing that. Additionally, the defendant was smart enough to contact the minor child when Mary was to be at work. They did it at a time where they could try to hide it. It was just happenstance that Mary came home from work early and caught this incident. If she hadn't done that, we would not be here because we wouldn't be able to have this evidence to present to the court. She's not going to go anywhere near the residence while she's on house arrest, but she can send other people. And the family court order is subject to the defendant as well as family. Anyone who has any contact with London through Julie or at Julie's direction. So that grandma knows she's not supposed to be communicating with her. And I know she's not subject to the order, but you could hear 2 voices with London. It was the defendant and it was her mother. They were both on there. And there is direct evidence of that. And Your Honor, I think the state has shown that there has been a clear violation of the no contact order.
And Your Honor, I'd just like to point out one thing. I don't believe either of the videos were actually admitted into evidence before the court. I don't believe they were, so I don't think the court can even consider those, except for what you heard in open court. But now, I've just, for the first time, started to bring in, oh, she has compatriots that are doing that. We have no evidence of that. That's all supposition. Based on what the state has presented here today, Your Honor, there's no violation of the order.
Let me do a minute order, guys. I'll do a written minute order for you. I gotta think about it for a minute.
Yes, Your Honor.
I think that the witnesses that the state put on were believable, the house arrest officer is believable. I think that there's probably evidence that grandma has contacted her. Somehow she got this tablet. Obviously, it wasn't Julie that went over there because we have the house arrest officer who says that she hasn't been there. the sad thing is that you guys are putting this little girl in the middle of this dispute that, you know, it's sad that anybody would want to do that to the little girl.
No.
So, I'll do a minute order for you.
Thank you.
Have a good day, guys. Operate.